Have you encountered what is referred to as the CSI effect on trial work?
Even way back then when I was in misdemeanor, it's always the prosecutor who would bring it up during the trial to lower the jurors' expectation, which I always thought was kind of funny, but not funny, because it seemed to me that they were trying to lower their burden. Like if they don't produce evidence that you think that they should have, then hey, that's not guilty. That's reasonable doubt. So for them to say, well, lower your expectations because, you might not see everything that you want to see because, you watch these movies, these CSI shows, and that's not the way it really is. But, it kind of is.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share part 2 of this conversation with Phoenix Streets. All my background has been on the civil side, and I know that in the world of criminal law, public defenders tend to try more cases than probably anyone else. How do you start developing a knowledge base of what an appropriate plea is versus, and I'm talking about you as a young lawyer, an appropriate plea deal versus, there's no way I'm letting my client take a plea. This case has to try. How do you learn the ropes in your early career?
Well, the good thing about our office is that there are people who have been there for a while, who have the experience. And I learned a lot by working with them, going to my peers for advice, and of course, managers, and fighting, what I initially would think. And it's like, this is wrong. This is it. We used to battle hard over things, sheriff work alternative program. So instead of going to a person having to spend time in jail, they'll have to do like community service. And that's what the sheriff work alternative program is. And so I'd be like, no, that's too much. That's too much. This person has a family they need to take care of. They have to work to feed the family. And if you, in 5 days out of their lives to do this, it's taking food off the table. And of course, fast forward a few years later, now I'm doing homicide trials or doing felonies where people are actually looking at significant amount of time in jail. So now I feel that way about this, about the years that people are going to have to do. But it was a lot of figuring out what a plea was worth, talking to others who have been around and making a mistake in either pushing too hard and the client winding up with a worse outcome than they could have gotten otherwise. And that pain, and of that mistake and what it cost the client is what helped me to quickly learn, the value of what a case is worth.
That makes a lot of sense. In terms of trials, if you're doing a record number of trials, can you give us a sense as to, are you in trial every day of the week, couple trials a week? What does it look like for you in your first couple of years in this misdemeanor unit?
Probably much in trial every week. And I did in 3 years, I did about 60 trials.
Wow. How long because I think of the time required to pick a jury, the time required to do all of the, opening, witnesses, closing. How long are these trials typically lasting?
I'd say typically 2 to 3 weeks.
That's a lot of trials. In civil work, one of the reasons we spend so little time in trial is, in our infinite wisdom, the Discovery Act was passed back in the 70s. And the good thing about that is every card in the other side's hand before you go to trial, typically if you've done your work. But it means that, you spend most of your time fencing with depositions and motion practice. Did you have much in the way of non-trial, whether they're prelims, whether they're any other motions to suppress, anything else that distracts you from kind of that central trial focus?
If it's a drug case, pretty much always going to file is automatic to do a motion to suppress, to try to suppress whatever evidence that they had regarding the drugs. And same thing with gun cases. And so, yeah, there's motion practice, but it was pretty much wrapped into the trial practice. And in part of our trial practices at the time, I did a lot of the investigation myself.
What does that look like?
What it looked like is, if, for example, if there is a client charged with an assault, I would go out to the area where it happened and speak to, if there was a witness, have the name, the number of the witness, the address. I would call the witness, go down with another colleague, because you don't want to wind up being a witness in your own trial.
Yeah.
Don't want to do that. And would go to the witness and talk to the witness and ask the witness questions. Also, if client's out of custody, go to the client's house and speak to the client's family. So as far as character witnesses, and if they had seen anything. And also go to the area where it happened to get a lay of the land to see where things occurred. And I think it's really important in trial work to go to where the incident happened, so you can see for yourself how far things are apart, where are things in relation to one another, to see, well, could that person really have seen what they say they saw, or heard what they claim that they heard? And also, if you see it for yourself, then it's easier for you to explain it to the jurors, because we didn't have a lot in the way of like we do now with the video, video surveillance and cameras and things like that. That's pretty much prevalent now. Didn't have that. Not even body worn cameras back then. And so everything pretty much you have to explain and paint a picture for the jurors.
That's an interesting tangent to go, or rabbit hole to go down for a minute or two. One of the things that we've seen from jurors is what is referred to as the CSI effect. That no matter how small the incident is, they're expecting some sort of graphic, some sort of visual, some sort of thing to help them understand the case. And when it is lacking, the side who has not produced that tends to get punished. Have you encountered that as time has gone by with all the gee whiz TV shows on trial work?
Even way back then when I was in misdemeanors, it's always the prosecutor who would bring it up during the trial, either in opening or in closing, to lower the jurors' expectation, which I always thought was kind of funny, but not funny, because it seemed to me that they were trying to lower their burden. Like, if they don't produce evidence that you think that they should have, then hey, that's not guilty. That's reasonable doubt. So for them to say, well, don't, lower your expectations, because, you might not see everything that you want to see, because, you watch these movies, these CSI shows, and that's not the way it really is. But, it kind of is.
When you are picking a jury, and I understand it may shift from case to case, but is there a general category of things that you're going to be worried about across all of the cases, things that you want to be asking potential jurors about?
My focus is always on their ability to be fair, and whether or not they're going to be biased. And if they're going to be biased, can they recognize that they're being biased and set that aside? One of the questions I ask jurors is, I'll say, when you look at Mr. or Miss, and now as you look at them, do you have any feelings of bias for or against them? And why or why not?
Do you find that people are as forthcoming as you would like them to be when you ask those types of questions?
Not always, but generally, yes.
When you're asking those types of questions, are you focused on the person that you're asking the question, or are you also aware peripherally of the people around for body language that might be giving you insight that someone may not be as forthcoming or willing to step forward as you would like?
I try to look at everybody, but I am focused on the person I'm talking to. I'm focused on that juror. And I'll ask that question. Now, if not just one, I'll ask every one of them. Juror number one, juror number two. They all are going to get to answer the question. And I'll look each and every one of them in the eye as I ask the question and as they answer the question. I try not to look away from a juror while they're speaking. I think it's important to keep the eye contact to let them know that you are listening to them. And I find that generally that becomes reciprocal.
In terms of the resources that the office has available, when you, and I recognize this may be different between misdemeanors and felony work, when you were picking a jury, trying cases, period, in the misdemeanor unit, were you there by yourself, or did you have anyone else, intern, note taker, co-counsel, or is it just you?
Most of the time, it was just me. There were times where I had a colleague, where there'd be another public defender. I got to work with a couple of really good misdemeanor attorneys. But for some reason, at the time, the judges didn't like us working together. Rather than see it as, because I saw it and supervisors saw it as an opportunity to work together and to learn from one another. And of course, it's always two better than one, so it's better for the client. But for some reason, the judges didn't like that. They called that they said that we were wasting resources.
Interesting.
So most of the time, it was just me.
And did that shift when you moved into the felony unit?
Not really. It was still just me. But then I had interns. But having an intern is nice to take notes, but it's still me and the client. You need to get to know your client. Number one, sit down and talk to your client. Get to know your client. Get to know what happened or what didn't happen from your client's perspective. And what are the client's goals and needs? So your first one is that's the number one thing, is to get to know what happened from the client perspective. Let the client know that you are there for them, that you're not the boss. You're working for them, and that you want the best outcome for them, and that you are listening to them. And a lot of times it's the one opportunity and chance that they get where somebody is actually listening to them and hearing them and talking to them in a way that is showing them respect. So do that. Listen to your client. And then, of course, do your other job, your lawyer job, which is making sure you know the law as it pertains to the case. The research, it never ends. And also talk to your colleagues. It's always best, I think, to talk to your colleagues about cases and to bounce ideas off. Because oftentimes, somebody will have a bright idea, and then they'll say it was just something simple that just, like it was nothing to them. Like, of course. And it's like an aha. What? That's brilliant. I'd never even thought of that, because there are often times where I have a case where I'm stuck and a colleague would come up with an idea that just is so simple, but it never crossed my mind.
When you talk about working with your clients, getting to know your clients, when you're working in the public defender's office, are there any prejudices that you feel that you have to overcome when people have a public defender? And let me be clear in terms of what I'm asking. I know that there are some people who, and given my interactions with public defenders, I would say wrongly believe that a public defender may not be potentially as good a lawyer as, say, a high-priced criminal defense lawyer. Do you encounter that when you have initial meetings, or have you encountered that when you've had initial meetings with clients?
Oh, yes. I've had that a number of times, especially when I first started. There's one time when in the court, I'm standing next to the client, and the client says to the judge, "I want a real lawyer." And the judge is like, "Well, he is a real lawyer." And he said, "No, he doesn't get paid." So yes, and I can't tell you how many times I've been called a public pretender.
When you've encountered that, that seems like a little bit of an obstacle in terms of developing rapport with a client. What tools have you used to be able to overcome that?
I just talked to them. It's like, okay, well, what do you think a paid attorney can do that I can't do? And I do get paid, by the way. You're not paying me, but I'm not doing this for free. So I am getting paid, and I'm getting paid decent money. I don't try to sell myself. And this is the way I feel too. I mean, if you can afford an attorney, then go ahead and go get one, and leave me to represent the people who can't afford an attorney. Because if you don't trust your attorney, you're not going to work with that attorney. And if you're not working with the attorney, then you're hurting yourself. And I don't want to have somebody have someone feel that they're forced, that they have no choice, even though they don't have a choice. I want them to feel comfortable and that I am knowledgeable and I do know what I'm doing. And that comes down to, once again, just talking to them about the case and explaining their options and asking them, getting their perspective on it and where they want to go. But once you lay down and explain the law to them, then they see that, okay, well, yes, this person knows what they're doing. And a lot of times, too, the judges will say, "Oh, he's a good attorney," and they'll sell us to the client or whatever. I just shouldn't say it like that, being, descendant of slaves. But, they'll convince the client. But it's really hard because some people, they're just hardwired that if you have a public defender, you're not going to get good representation, which, there's basis in that. I mean, for people to believe that, because public defenders' offices are still around the nation suffering from lack of resources and way too many cases, that it's nearly impossible to provide quality representation. I mean, when you have hundreds of cases a year as an individual attorney, there's no way you're going to be able to work on all those cases and meet all those clients and do all the research that you need to do. So I understand that there is a basis for that belief that people have. Now, unfortunately, in San Francisco, we aren't like that. We have the resources, and our caseloads are somewhat manageable. They got up high within the last few years, but they're going back down. And so we do have the time and the resources to provide good quality defense. And I think when Jeff Adachi took over the public defender's office, and he was able to change that narrative.
I did want to comment on, for those who are listening and not watching, your T-shirt today is a picture of Jeff Adachi, correct?
Yes.
And when you say he helped change that, can you articulate a little bit what you mean?
He would actually go into the different neighborhoods where we have a lot of our clients, and he would have these community events. He would go speak to individuals. And so people got to know him, and through him, the office that he led. And then he'd also give news, press conferences where he's calling the police out on the things that they were doing, such as having people sell drugs, stealing from people who are living in single residency occupancy, like these poor hotel rooms. Jeff would do those sort of things. And so because Jeff was so out there on this platform and letting people know what we were doing and what the public defenders were all about, and he worked closely with other organizations as well.
What types of organizations?
It would be neighborhood organizations where they would, I can't think of names right off the top of my head, I'm blanking, sorry about that. But it would be organizations that are fighting to prevent violence, people who are recently released from prison, working on rehabilitation and getting them jobs and housing and reintegrated back into society so that they could learn a trade or go back to school, working on housing, those type of organizations. And in fact, he broadened our office from being more than just providing the criminal defense to actually helping kids with school supplies and a place to go after school and during the summer, and also backpack gives away. So we have the Mo Magic, B Magic programs, and that's what they're about.
And another piece that, and I don't know if this was something he did or something that the public defenders had always done, I came across the expungement program that seemed to be very proactive in outreach in terms of letting people know that it may be time for us to help you remove this from your history so that you can move forward with your life. Was that something else that he was involved with?
Yes, Jeff really, it's called a clean slate.
Oh, thank you.
And so that was something that was near and dear to his heart. And so he created our clean slate department. And yes, and it was very important to him that the clean slate unit there would be an outreach to the community, knowing that we have this resource. Please come in.
For those who are listening who may have come across a client of their own where this might be an appropriate program, can you articulate a little bit what an expungement is or what the clean slate program is?
If you've been convicted of a crime, misdemeanor or felony, and you've completed your probation or parole, haven't picked up any new cases, or time has passed, years have gone by, and you want this conviction taken off your record, cleared, or what we call expunged, then you contact our office. Our office will speak to you, draft a motion, and file it with the court to seal your records.
It seems like that would be a nice way for people who have gotten an era of their life behind them to be able to move forward, particularly in terms of employment in other areas.
Absolutely, especially in the area of employment, because felony conviction prevent a lot of people from having jobs and moving up in the ranks of jobs, because there are certain jobs that just will not accept you if you have a felony conviction.
When you moved over to the felony unit, is it broken up into different types of cases, or is it just kind of across the board? You get a docket and you go.
Normally, the way it happens is you go from misdemeanor into the swing unit. In the swing unit, you're covering felony attorneys' preliminary hearing matters, which is right after you get arraigned, because first you're arraigned on what's called a complaint. And if you can't resolve it, then you have what's called a preliminary hearing for the judge to make a determination of whether or not there's enough evidence for this case to proceed forward. And then if the judge decides that there is, then you're held to answer. Then you go on to get arraigned on the information. And so the swing unit covers the prelims, and that gives, an introduction into the felony rotation. The good thing about it is it's a slow break in, rather than being jumped right into the ranks of the felonies and having the felony caseload. And so you get to really know the value, you get to learn the value of the cases. And since they're not really your cases, you're working with somebody who's senior and will help you out, let you know how they think the case should go. Well, that wasn't the way it was for me. I went straight into felony.
Okay. Do you think there's a reason for that? Was it because you had tried so many cases? Was it because they were shorthanded, or just luck?
For both of those reasons. Because I actually was in misdemeanors for 3 years, normally like 18 months to 2 years. I was there longer because of politics It was at the time that Jeff was the public defender, but Kamiko Brown he was going to be, but he got fired by Kamiko Burton, who was appointed to be the interim public defender. And she knew that he was the heir apparent, if you want to call it that. So she fired him. So because I was seen as somebody who was one of his supporters, or minion or whatever you want to call it, then I was basically put on ICE in the misdemeanor unit, which is fine with me because I was still enjoying it. It was just a blow to the ego because, hey, in a sense of fairness, because it was my time, but what can you do? And so I was there longer than most people would have been. And so that was one of the reasons that I went straight into the felony rotation. And also because we were pretty shorthanded.
I asked a kind of a clumsy question earlier in terms of felonies. When you hop into felonies, are you immediately doing homicide and high profile cases, or do you work your way up to that?
Yes, you absolutely work your way up to that. We start with everything but homicides and sex cases. And you work your way up to, which is interesting because you can actually do attempted murders, but not murders.
As we talk a little bit about resources for the public defender's office, I know that there are some cases where there may be a need for either graphic evidence or an expert of some sort. And are there occasions where you need, say, a ballistics expert or some other piece in a case?
Pretty much most of the felony cases, we're going to need some type of expert, either a drug expert, psychologist, psychiatrist. Almost always we're going to need some type of expert.
Without getting too granular, is there a way that the public defender's office or say you with your caseload is able to present and make a request for a budget as far as that's concerned? Or is it universally approved? If you feel it's necessary, you've got the authority to go out and get someone?
Yeah, we have a process that we go through because our office has a budget for experts. And so we have to submit a request because we have a person who's in charge of the request. And that person will either say, hey, I need granted outright, or say, I need more information. Or do you really need that? And then once they agree and they approve it, then it goes to Matt Gonzalez for the ultimate approval. But you have to justify why you need an expert. You can't just say, I need an expert with no explanation.
Tune in next week for part 3 with Phoenix Streets. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.